Did you recognize a process server?
I do not.
Until she noticed that she was getting garnished.
But the first I just learned of saying that I served a man instead of a woman was right here in these proceedings.
This is RPM Auto Sales versus Caitlin Persons. We have Mr. Cradaville representing RPM and Mr. Birch representing Ms. Person. It sounds like you guys have agreed that this is really sort of a discrete question, and the question being whether the process server will have served this person. I think that Mr. Birch probably indicated that there is probably going to be a high likelihood that the process server won't remember actually serving this person, even if she did serve her. It's probably not going to be something that would have stood out in her mind, but I guess we can always investigate to see if that is a possibility because of the way that some people work. So Mr. Cradaville, I guess is going to be your witness based on the fact of what it is that Mr. Birch said, if you're in agreement with what he said, I guess.
Yes, Your Honor. I mean, I guess I do potentially have, well, I don't know if it involves questions to the defendant. But yeah, no, I guess it's just part of my general argument against the motion to set aside the default. But yes, I do have a witness who is the process server whom's affidavit was furnished to the court in order for us to get our default judgment. So she is here. I've chatted with her a bit, so I think we're ready to proceed if the court's ready.
I guess I should swear her in. Can I get you to raise your right hand, please? Ms. Kiesler, do you swear or affirm that the information that you're going to provide to the court will be the whole truth?
Yes, I do.
All right, you may lower your hand if I can get your full name and if you can spell both the first and last name.
Crystal, Cristal, Castler, Casler.
Kessler, okay. I think I said Kiesler, so forgive me. Okay. Mr. Cradaville, if you'd like to inquire.
All right, thank you, Your Honor. Ms. Kessler, who are you employed by?
Great Lakes Civil Service Process.
Okay, thank you. And what is your job for them?
I'm a contracted process server.
Okay. Do you have an estimate as to approximately how many times you serve process in any given, I don't know, easiest way for you to estimate, week, month, etc.?
Probably in this past year, starting, obviously there's an ebb and a flow to it, different times a year, but on average between 50 and 80 documents in a week, 1 week, 7 days.
Thank you. That gives us a general idea, I think. Thank you. Are you in possession, do you have in front of you the proof of service that is relevant to this case today?
Yes, I do.
Okay. And so on that proof of service, you indicate, I want to make sure it's accurate. You're indicating on this proof of service that you personally served a copy of the summons, complaint, and attachments to Caitlin Pearson, who's the defendant in this case. Is that correct?
Yes, it is. It is. That is the box that's checked on this document. That's correct.
Okay. And this would have taken place based on this document, May 4th, 2024 at approximately 6:05 p.m.?
Yes, that's approximate. It just depends on when I log it into my tablet when I get back to the car.
Okay. And I had a question. Do you have any, and you see, and obviously you're not in person with the defendant, but she is there and on Zoom. You've had a chance to see her. Does that refresh your memory? Do you have any specific memory of this event of service of process to her?
I do not.
Okay. I guess one other question. There's a description section, physical description of the person served. Is that correct?
Yep. Yes, I see that.
When do you generally fill out that information?
I always fill that out when I'm back at the car. I have a tablet that I use for this job for everything that I log, and it's about, 4 inches by 8 or 9 inches. So I leave it in the car. I always leave my hands available in case I need to defend myself physically if somebody gets, in an altercation with me. It's just a standard procedure I have.
Okay. And, all right, considering how much, process you serve, does it surprise you that you're seeing that you would see somebody 5 or 6 months later that you had potentially served and you would not remember them?
No, it definitely doesn't surprise me because, like I said, I've had a pretty high volume. So it's just, only usually what I remember the most is when it doesn't go well. Those ones, if there's any kind of issues in the service, that sticks out more.
Okay. And to your knowledge, have you ever served a male and then on an affidavit to the court stated that you served a female?
Have I ever made a mistake and said it was a male when it was a female?
I wouldn't say made a mistake. So in this case, you described the defendant as being a female, and she is a female. Her statements that she's made to the court is that a male named Nicholas was actually the person that was served. To your knowledge, have you ever served a male, but then indicated on paperwork to the court that you actually served a female?
No. Now, thank you for clarifying the question. No.
Yeah, sorry. Okay. I mean, as you don't have a specific memory of this, I'm not sure how much else we can glean, but looking at this document, this does look like a document that you prepared, correct? Is that your signature in the bottom right?
Yeah, so the document is actually prepared by the office and then it comes through electronically to me and then I approve it. So I review this not in a printed out fashion, but in a online fashion, and then I approve it by approving my signature.
Understood. Okay. I don't think I have anything further, Your Honor.
I'm just kind of curious to see how you would describe the young lady that is seated next to Mr. Birch. How would you describe that person? Is that consistent with what it is that you indicated in your descriptor about, I guess, in the middle of the proof of service?
Sure. I mean, right now I can't see how tall she is standing there, but right now, I mean, she would have, either light brown hair or dark blonde hair. I mean, I can't tell how tall she is, but yeah, I would say she's about 30 years old and a female, and she's white. That's what I would describe her as.
Also has a weight for her.
Yeah, not seeing her stand, and of course there's distorted to me through video. Hopefully I look extra fat in video. I don't know. But yeah, she looks, I don't know, taller than me, just sitting there, and like she would weigh just a light to a middle weight. So yeah, 140, 150, around there. Sorry.
That's generous of you. Wow. That's generous. I wish.
All right, Mr. Birch, would you like to do a cross-examination?
Yes, I would, Your Honor. Thank you. Ms. Kasler, you only went to that residence one time. Is that correct?
I can't tell by this document that I went there once or not. I can just, what's on the document is the service.
And your description, it does not state like roughly, approximately. Why is that?
The application that is used is called, let me see what that's called. It's called, hold on one second, I've got it here. It's called PST Toolbox. So they don't, I click things on this application, so it doesn't give me those approximations. They are approximations, but it doesn't give me that option to say approximation.
Did you ask Caitlin Pearson, allegedly when he went to server, did you say, are you Caitlin Pearson?
When I have a standard procedure that goes like this. Hello, my name is Crystal. I'm a process server. I'm looking for, and then I say that person's name. And then they either say, yes, I am, or no, I'm not, or we go from there. That's usually my procedure. I identify myself first, and then I usually say, I'm looking for, and then I say that person's name. In most situations, that's how I present it. Sometimes I don't even get to get that out before somebody's telling me to get off their property.
Was it possible that you gave it to the male resident there and said, please give this to Caitlin Pearson? Is that possible?
That is not proper service. That is not what I do. So I believe that is not possible.
Now, my client weighs about 180, 190. So your description is about 40 pounds off. Now that's a huge gap right there. Wouldn't you say that's a huge gap?
I don't have a specific answer for that. I'm not somebody that's paid to decide how much somebody weighs. I probably tend to be more generous than say somebody's really big. Only when it sticks out that they're really heavy do I usually say that they're heavy. I mean, I weigh 180 and I don't feel like I look like I'm 180.
And you don't recall that if there was a male there, he said, hey, Caitlin is not here. You don't recall that, do you?
No, I do not have any recollection of this. Initially, I was sent a picture of the building and something else, and nothing jogged my memory at that time. But right now, I only have the printed proof of service in front of me. But at the time that this first was brought to my attention, nothing jogged my memory at that time either.
And can I ask you, do you run like a driver's license, a report ahead of time to get a description about the individual you're going to serve?
No, I do not do any of that. Every now and then there's pictures given to me of individuals that I serve. I do not recall in this case any of that.
Your Honor, I don't have any further questions, but I do want to call my client to the stand.
Okay. So in this case, so you said that you weigh approximately 180 pounds.
I weigh approximately 180. That's correct.
And so when you look at Ms. Pearson, you're saying that you believe that even though she might be about your stature, that she probably weighed 30 pounds less.
Yes, to me, I think she looks like she weighs less than me. I'm pretty stocky, but I'd have to see how tall she is, and that would help me too. But yes.
You probably couldn't really tell if I had her stand up right now. You probably still wouldn't be able to tell how tall she is, would you?
No, I wouldn't be real accurate, but I usually, I guesstimate. So I usually do like a 5'6" is the average I do for a woman. If they're a little taller than that, I'll say taller. If they weigh a little more than average, then I would bump up the weight. But usually 150, 160 is what I put for the most common things, unless I have outliers in what the person presents to me.
So unless a person looks like they're pretty thin, or if a person looks like they're pretty heavy, in other words.
Right. She looks thin to me versus a heavier. If I was going to say heavy, she's not really skinny. She's not really heavy. She's in the middle to me, which is about 150, 160.
Okay. So no doubt in your mind, though, that you didn't serve some guy because you said that would be improper service. Is that right?
Well, based on what's on this document, absolutely. It would have had to have allowed me to do, sometimes there's subservice that's available, but there's nothing that says subservice or anything. So no, that is not what I would do based on this document.
So when you say subservice, you're really talking about either substituted service or alternative services, what you're really referencing.
Yes, sir. So substitute service is the only time that I would serve somebody different than that person when it specifies that I can do that. And then that's when I would serve a man when I'm looking for a woman and say substitute service to that person.
And I think in those situations, there's a court order that says that you can have alternative service and that it is to anybody over the age of majority, like 18 years of age, or someone that seems like they're of suitable age and discretion that they will deliver the document. That's what you're really saying.
Yes, sir, that's correct. When it specifies that I can do that in the documents that I receive.
So a member of a household could receive it, even if that person was not the person that it was directed to, as long as you had an order from the court that allowed for you to do that.
Yes, sir, I have had those orders before.
And in this file, I'm leafing through and I don't see an order, and I'm guessing that you didn't find one in your file as well. Otherwise, you would have brought that to our attention.
Yeah, yes, sir. Can you repeat that real quick?
That I was saying that you did not find an order for substituted service in this file. I don't see one either, but.
No.
You would have
No,
been
I do not.
So when Mr. Cradaville got in touch with you, that would have probably been one of the first things that you would have just checked for, because you didn't have a specific recollection. But because they said that you served a man instead of a woman, you would have checked to see if you had the ability to do substituted service in this case.
That's correct, but the first I just learned of saying that I served a man instead of a woman was right here in these proceedings. So I did not have a chance to look for that specifically because it was not brought to my attention until right now.
I'm sorry, I misunderstood. I thought Mr. Cradaville had told you about that earlier.
Earlier today.
Okay. All right. I believe, Mr. Cradaville, you have an opportunity to do a redirect.
Yes, Your Honor. I mean, how many times have you, if you had to guess as to how many times you've served people? Do you have a guesstimate over the last? How many years have you been doing this, Ms. Kassler?
It's coming up upon 5 years sometime in the next couple of months.
Okay. And how, I mean, I don't need a specific number, and I doubt you'd be able to provide one, but would it be accurate to say you've served thousands of people?
Yes, that would be accurate.
Okay. How many times have you, prior to today, been in court to defend the fact that you served the person that you said you did?
Never. This is the first time.
Okay. I don't have anything further, Your Honor. Obviously, she doesn't have a specific memory, so I don't
Okay.
know what the court wants to do.
Ms. Kassler, thank you so very much for your time. You're actually free to go about your day if you like to, or if you'd like to stick around and see what I decide, you can do that as well.
Okay, I'll just sit here and watch you, sir. Thank you.
Okay, that's fine. Mr. Birch, you said that you wanted to have your client sworn in as a witness.
Yes, please, Your Honor. Thank you.
Let me just double check with Mr. Cradaville to make sure that he does not have another witness.
I do not, Your Honor. There is another member, employee of Great Lakes Civil Services here. I don't think we need her. Just kind of here observing. So, Ms. Kassler, I think.
So it sounds like the plaintiff rests. Mr. Birch, your case now.
Okay, thank you, Your Honor. Caitlin, can you please state your name for the record and spell it?
You need to do this the right way. So you're going to call the defendant as a witness in the case, is that right?
That's correct, Your Honor.
If I can get you to raise your right hand, please, ma'am. Do you swear or affirm that the information that you're going to provide to the court will be the whole truth?
Yes.
And lower your hand. Your name is Caitlin Person. If you would please spell that for the record.
Caitlin, Kaitlynn, and Pearson, Pearson.
Mr. Birch, she is your witness.
Okay, thank you, Your Honor. Caitlin, what kind of work do you do?
I am a server at Jolly Pumpkin. I am also licensed in cosmetology, but for work right now, I just work in the restaurant.
Did you recognize Crystal Kassler, the process server?
I do not.
Now, she alleges that she served you on May 4th, 2024 at 6:05 p.m. Is that true?
That is false.
What day was May 4th?
It would have been a Saturday.
And where were you at that time? Do you recall?
I do. I was actually at the dog park with my husky. I do have text messages that state that.
And who did you reside with at the time?
As far as living.
Yeah. Who else was in?
Oh, I was like, so that would be my roommate, Nicholas DeLuca. We have lived together at the time we were living together for 3 years. So he is the only other person along with me and the dog that resided at the home at the time.
Now, that day in question, was that the only time that a process server had come by to serve you papers?
From what I'm aware of and what he told me, because I received a phone call, yes, this was the one and only time.
No one else attempted
I
to?
don't think I actually heard a hearsay objection, but it sounds like classic hearsay, Mr. Birch.
Understood, Your Honor. Okay, now, Ms. Pearson, you can't testify to what somebody told you, okay? You can only testify to like Ms. Castler, but you didn't meet her. Now, is it your testimony then that you were never served?
Correct.
And to your knowledge, who was served?
Nicholas
Okay, say his name again.
DeLuca.
And I presume Nicholas DeLuca gave you the papers, the complaint summons. Is that correct?
Correct. He had called me 10 minutes, well, not even 10 minutes afterwards, after I would assume she had left, and told me that
Right back into hearsay.
I'm sorry.
Okay, you can't testify to what he talked to you about,
Okay.
but you're saying Nicholas gave you the document.
He gave me the documents, correct.
Now, Ms. Pearson, is there any reason for you to lie to the court about not being served?
Absolutely not.
And can you give me, you've read the description. It says age 30. How old were you back in May?
28.
How old?
28.
And it says your height is 5'9". Is that correct?
That is correct.
Okay, and it says your weight is 150. Is that correct?
No.
Okay, how much did you weigh at the time, would you say?
At the time, I was probably about 187.
And then it says hair, dark blonde. Is that your type of hair?
No. If anything, people get excused that I have dark brown instead of red hair.
So you're saying you have red hair,
Yes,
correct?
I would categorize that as a reddish brown is what they categorize me as.
Just a second here. Well, Your Honor, I don't have any specific questions, pending your questions and cross-examination.
Okay. Next up, Mr. Credibility for this cross-examination.
Thank you, Your Honor. Ms. Pearson, so is it your testimony that you received the paperwork, in this case, the summons and complaint, the same day, May 4th, 2024, that you claimed that Nicholas was served with the paperwork?
Yes, that's correct.
Okay. Because you were still living at the 3013 Belmar Circle, Apartment 5 address at that time? Is that correct?
Correct.
Okay. When you received that paperwork, what did you do with it?
I just I was skimming it because, this is the first I've heard about all this since 2017. And I immediately sent texts both to my aunt and to my mom, just stating that, he had gotten the call and I was just trying to figure out what to do. And the next day I went ahead and made phone calls to attorneys in Michigan to see what I'm supposed to do. I've definitely never been in this position, so I just wasn't sure how to go
Sure.
about it. So I just skimmed it and sent some texts to family members, and then I went about it.
And that was again,
The same
just
day.
to verify, that was back in May.
Yep, May 4th, Saturday. Correct.
Okay. And when is the first time that you filed anything with the court in this case?
I mean, a date on that, I mean, I don't know. That's when I had gotten into contact with the attorneys to see.
Okay.
I don't know.
I guess maybe a better question, I apologize, that wasn't a great question,
No, it's
would be, is there a reason why you did not file an answer to the complaint in this case?
Well, once I had seen that there was a deadline and once I had gotten a hold of my attorney and I had one that would deal with the case, Don, we said, once I explained my case and that I was not the person who was served, we said that we would go about on the wait to see if we would then make it improper, and which is where we're at now. So I was told until we hear anything more, because it was, to not really make that statement. And then afterwards, I didn't hear anything for a few months, and then my work got sent that they would start then garnishing my wages because I didn't make a statement.
Gotcha. So it's your testimony that you contacted numerous attorneys and their advice was just to wait until later to do anything about the case?
Correct.
Sounds like we're getting into hearsay with them now.
It's fair, Your Honor. Did you read the summons when you received it,
I did.
Ms. Pearson? Okay.
That's correct.
Okay, I don't have anything further.
So let me ask a couple questions so that if you want to, Mr. Cradwell or Mr. Birch, you can follow up. So, and I don't want to sound flippant or something, but you read and write English, right, Ms. Pearson?
Yes.
And to kind of follow up on what Mr. Cradwell was saying, there is something called a summons, and summons actually advises you of what your rights are. It says something along the lines of you are being sued. And depending on how you were served with this piece of paper, you either have 21 days or 28 days to respond. And this is your testimony that you didn't respond in that time frame.
Correct.
Is there a reason that you didn't respond other than the fact that it sounds like you thought that you had gotten advice with regard to that question? I mean, was it something that you decided that you were going to either do or not do?
Well, it was something once I heard, after I received, improper, that's what, I believed, but also was advised because I wasn't sure how to go about it. So that's why when I went about to call everybody and then I had someone who would represent, and I explained the situation and that I wasn't the one who received it, that was then the action to move forward with.
But you don't know at that point whether there is authorization from the court for you to receive it by virtue of somebody else giving it to you.
Correct. This was a discussion that was beforehand, before the deadline, and so it was then just,
What deadline are you referring to?
for the summons, for me to make an answer. I believe it was, I'm not sure if it was May 22nd or the 26th, along those lines, because if it would have been the days after the 4th, the 21 or 22 days, then we didn't, we decided since it was improper to then just wait. And then they went ahead and went with the garnishment.
So you don't have like a learning disability or anything like that. You knew and understood for yourself that you had an obligation to respond based on what the summons said, irrespective of what somebody else might have told you. You know what that summons said.
Correct.
Okay. I don't know, Mr. Cradwell, if I generate a question for you or if it generates a question for Mr. Birch, but I'm done asking questions.
I just have one more quick question, Your Honor.
Sure.
Are you still residing?
Well, let's not talk about what her address is, because again, this is being broadcast over the internet.
My apologies. At this, are you still residing at the same address that is on the proof of service?
No,
Okay. Do you approximately, well, I'm curious when you moved out of that address?
it would have been the end of July, and there was an address change the day after.
Okay. That's all I had, Your Honor.
Okay. Mr. Birch?
I do not, Your Honor, but Your Honor, may I kind of myself elaborate, because I remember when my client came for a consultation.
Well, I think that's your argument. You want to make an argument, right?
Yes, Your Honor.
So you rest at this point. You don't have any further witnesses.
No, Your Honor.
All right, so I guess the way that this is supposed to work, Mr. Cradaville starts with the argument, you reply to it, and then he sort of replies to your argument, and I make a decision.
All right. Thank you, Your Honor. Obviously we have an imperfect system here of service, but my process server testified that to the best, she testified that she did not remember this person, which is it's not surprising or unusual considering the volume of process. But that nothing about this proof is particularly noteworthy. I don't think being off, she's guessing someone's weight. I don't think is, I don't know. I don't think that's substantive information for the courts, but obviously Your Honor can do with that what he will. What I do find interesting is that, the defendant testified that she had the paperwork in her hands the same day as indicated on the proof of service. And while that does not mean that service was correct, it does mean that she had the documents and she's testified that she understood that there was a deadline for her to answer. That deadline passed. My office did submit a request for a default and a default judgment, which this court did grant. Upon that being granted, my office then mailed her a letter. This would have been at the end of June. Mailed her a letter saying, hi, we've got a default judgment if you'd like to make payments, etc. Attached a copy of that default judgment. We then filed a periodic garnishment in the beginning of July. Now, I cannot tell you when her employer served her with that garnishment. Obviously, we don't serve her with it, but I can tell you that the first contact with my office from Caitlin or somebody representing her was on August 26th, which was of 2024, which was, we had received 2 garnishment payments already from her employer prior to that date. So I guess what I'm indicating is I think she knew that this was going on and she chose not to participate. And I don't know if that's kind of what's envisioned by the court rules cited by Mr. Birch in his motion. So I do think she had an ample opportunity to avail herself of the court, and for whatever reason, and I make no judgments here, but chose not to do so until she noticed that she was getting garnished. And so, I would ask the court to deny the motion, allow us to continue to collect on a judgment.
Mr. Birch?
Yes, thank you, Your Honor. Your Honor, I do recall when Caitlin came into my office and she told me about the service and I said, that's not proper. I said, let's just wait, because I had assumed then that, okay, it was given to her roommate, but then that there would be another attempt because it was a male, it wasn't a female. And Your Honor, if you were to deny this motion, well, that goes against the court rules, Your Honor. There was no personal service. It doesn't matter that it was given to a friend who then immediately gave to her and then she didn't answer. It circumvents the court rule. And Your Honor, I cited the grounds for relief from judgment. And And Your Honor, I'm saying there was misrepresentation.
What is the grounds for release from the judgment? It's a specific ground that you're alleging.
Well, Your Honor, I'm alleging that there was fraud.
So you're saying it's fraud on the court, that there was a submission of a proof of service that you believe was defective because service was not appropriate because there was no order for substituted service.
That's correct, Your Honor. It says fraud, misrepresentation, or misconduct. And Your Honor, I mean, you know, I'm not here to say Miss Kasler did something wrong, but there, and I think a light word is misrepresentation, but clearly there was a description. My client says it was not her. And Your Honor, also too, that court rule, parens F, states any other reason justifying relief from the operation of the judgment. And Your Honor, that just kind of goes back to what I was saying, that she was never personally served. And so to state that, oh, it was given to somebody, she didn't answer, no, that's not correct. And Your Honor, I would just ask that the default judgment be set aside. I would say in the justice requires that the case can continue. I would like it to be dismissed without prejudice or with prejudice and then refiled. And then, Your Honor, I would ask too that the garnishments be given back to my client. Now there is an issue. We don't quite know yet the amount of the garnishments. But Your Honor, I just think justice requires if that this case continued.
So how is this really different from the entry of a default judgment where you have to show that there's good cause in the meritorious defense? How is this different?
Well, it's because of the personal service, Your Honor, and that court rule talks about the personal service. Your Honor, the other court rule is you have to state like a meritorious defense. But Your Honor, those are cases where people were personally or service was proper.
So how is this different fundamentally from a case where you have to show good cause in a meritorious defense? Because I'm not really hearing that in your argument.
Well, Your Honor, there's a whole separate court rule based on that.
I understand that, but I'm asking you, how is it different? That's my question to you.
It's different because of the personal service, Your Honor, was not correct, was not affected properly.
So in a situation where a person is trying to set aside a default, much like what you're doing, you don't have to show good cause.
No, Your
Or
Honor.
you can show good cause that inquiry with regard to that particular motion is somehow less of an obligation than this is less of an obligation to come in and move to set it aside after the fact.
That's correct, Your Honor. And it's based on, I don't want to beat up the points, but I mean, it's based on what I cited, Your Honor. I mean, I'm not, to me, number F, parens F, any other reason justifying relief from the operation of the judgment. But Your Honor, that's MCR 2.612 C1, parens C and parens F, but none of that states a meritorious defense needs to be presented. It's just going right through.
Just asking from a philosophical standpoint, how is this different? And I don't know that I see that there is a distinction. I think that really the distinction that might be drawn by most people is what is the time frame for you to be able to set aside the default? That it usually is a much quicker time frame if you're bringing and showing that there's good cause in meritorious defense. That you can actually bring a motion to set aside a judgment maybe up to a year after.
Well, that's what it says. 2 is up to 1 year. You can
Right.
bring this motion and then I think parens 3 applies here. This sub-rule does not limit the power of a court to entertain an independent action to relieve a party from a judgment or to grant relief to a defendant not actually personally notified, as in sub-rule B.
She actually mentioned that she had been personally notified. She had the document in her hand the same day.
But Your Honor, I just, it's still.
I understand your argument. I'm not going to belabor the point. The hour's getting a little late. I think we're already after 5 o'clock and I still have my staff here. They don't get compensated for being here after 5. Mr. Crabbill, did you have something else to add, sir?
Very briefly, Your Honor. I think it's a stretch to argue that the filing of this proof of service constitutes fraud. I'll let the court judge that for themselves, but Ms. Kessler, I mean, I'm sure she's got there's no motivation for her to do something like that. And the other thing I wanted to mention is in defendant's own affidavit in support of this motion, she indicates that she contacted Attorney Birch on or about August 1st, 2024, when defendant noticed that her paycheck was garnished, which kind of goes to what I said, which to me means she got the paperwork, she, didn't want to deal with it or whatever. Again, I'm not making a value judgment. It didn't matter to her, I guess, until all of a sudden her wages were being garnished, and then suddenly it was a problem. And I say that because I see that all day, every day, in the practice of what I do. To Your Honors, well, I don't know if it's a point you're making, you're just asking questions, but that good cause requirement under the other court rule that people are often filing the motion to set aside the default judgment under, I don't believe she would have established here, which is probably why that rule is not used. I don't have anything further.
Don't you get some arguments that make you sort of wonder why they're making an argument? All right, so I'm going to rule in favor of the plaintiff with regard to this matter. I am not going to grant the set aside of the judgment. And the reason I'm going to do that is because I find Ms. Kessler to be believable. She said in no uncertain terms that she would have noted if she had actually served a meal, that she had never actually served a meal and thought that she had served a female, that she's ever in the 5 years of serving process, never had her service process called into question. And that the preponderance of the evidence seems to suggest that Ms. Pearson really was not interested in responding, despite the fact that she could read the summons for herself. And the summons said, you have 21 days to act, or 28 days, depending on how you received it. And she did not act. In fact, Mr. Crabbill makes the point that until she had actually been garnished, she didn't see the necessity of acting at all. And so I find that I believe the testimony of Ms. Kessler, because she didn't have any sort of reason to perpetrate any sort of fraud. If the facts be believed that Mr. Birch said that she made contact with some gentleman by the name of Nicholas, and of course I said that we cannot hear from any testimony about Nicholas because of the hearsay rules. I mean, it was certainly an opportunity. Mr. Birch knew that this hearing was coming up. He could have subpoenaed Mr. Nicholas and had him here to testify, but for some reason he's not here. So just being left with the information that I have in front of me, I find that there is no reason for the process server to commit a fraud. I mean, and you guys do this type of work just like I do. The fact that she had made contact with somebody at the house meant that she could actually have gotten substituted service, that I would have signed an order for substituted service, just based on the fact that there was somebody that was at the house that knew who this person was and could get her the the summons and complaint. So I don't find that she had a reason to really lie about it. She said, you know, she's never actually been alleged to have served somebody of a different gender than what it is that she served. And the description she said, this person, even though it's not exact, she didn't try and fluff things when she was being called on it today, when she was being cross-examined. She said that it was approximate, that this PST program that she uses does not give exact data or figures in terms of weight and height and stuff, but generally speaking, even though the hair color sounded like it was a little bit off, but the height was right on the point. It was the gender was right on point, and some of the things that are the other indicia of what it is that they're supposed to look at makes me believe that the preponderance of the evidence suggests that I can hold on and believe the testimony of somebody that didn't have anything to gain by not telling you the truth to work to that. So I'm not going to set aside the service of the summons and complaint. And so the default judgment retains its viability. Mr. Birch, this was your motion. Anything else for the record today?
No, Your Honor, I don't have anything else, Your Honor.
Mr. Craddock?
No, sir.
I would encourage you guys to talk. I mean, I'd hate for you to have to go and do a whole bunch of machinations that are just going to run up the bills, and there's really no real defense to the obligation that she has with RPM. But I mean, that's for you guys to determine, and you can determine to disagree with me, but certainly as I look at the matter, it looks like this is should get engaged in a cost benefit analysis to determine what the next steps are going to be, whether the juice is worth the squeeze. Okay,
Thank you, Your Honor.
Okay,
All right,
thank you.
Joe.
Your Honor.
Appreciate your time.
Have a good day.
All right, thank you, Your Honor.